side. Goddamn. Goddamn. Sooner or later, I'm gonna have a goddamn print eye me take them. Damn, take it on. I can't deny her though. She's my bestie. She's my bestie. That's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever high. Can watch you all day, girl, like you televised. You think like this nigga, they ain't never lied. I left the bitches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. Trying to get mad at my bestie, I tried. That's my bestie. My pretty.
I heard she's the one. She's got it going on. That's my pretty ass baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty ass baby. Yeah, yeah. I heard she's the one. She's got it going on. That's my pretty ass baby.
Hello, hello, hello. It's me. Put your eyes on me. It's Pretty Eyes Teeth. Anyways, I'm here with the Karen Read, the last motion hearing before the retrial, baby. Alrighty, so I'm here to watch it with you guys. And I hope you drop down, hit the like, share the live, comment, all that great stuff. Sub if you haven't, and enjoy the ride with me because this case is wild. Anyways, all right, let's get to it. Okay, you cannot see me. Hold on. Banner, goodbye. Be gone with you. All right. Now you can see me, I guess. Somewhat. Let me get rid of my name too. Do 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 do. No. There we go. Goodbye. All right. Okay. Now let's get started. Shoot. I will speed this up because they talk slow for me. And I figure I'll deal with the fastness during the trial. I mean the slowness during the trial. Because that's when we need it. Come on, baby. Right about there.
Yay. All persons have any business before the Honorable Beverly Canoni. Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Read. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Mr. McLaughlin.
Yeah.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Read.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Read.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Yeah, give us the Sally Port
Your
video.
Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sally Port video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sally Port video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified.
Nope.
But there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged.
Yes, Your Honor. They shouldn't be asking for this fucking video for 3 years. For 3 years, they've been asking for this video. And, you know, Hank Brennan's been dilly-dallying, saying, oh, well, I gave him video that I knew that they didn't have in the beginning, blah, blah, blah. Gave them the whole runaround, made them come in, give them have their expert go all the way out to Massachusetts from wherever they're from, and try to collect the data, and all of a sudden it's not there. And then they come to court the next time, and Brennan says, oh, well, you know, they want it, they got to come download it from this person. And then they go back to court, and again, it shouldn't be like this. Like, that is the main key in this whole investigation is her car. The fact that they didn't take pictures before they even towed it to Canton PD, that there's missing Sally Port video from that 42 minutes to be exact. They got grainy footage. They got an inverted video. They've dealt with it so much. And after the first trial, they get handed over a video of Brian Higgins on the phone at 2:22 a.m. in the morning when he said he wasn't on the phone. It was a butt dial. Come on.
For our review.
Okay. Thank you, Mr. Brennan.
Hey, Cold Pepsi, how are ya?
It seems the defense characterization that's forensically sound
You know,
is fluid. It's difficult to follow. What is clear?
I'm so tired of your bullshit, Brennan. Like, she didn't attack. She didn't say the Commonwealth is blah, 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 playing around. No, she's saying that somebody is playing around with the video. If it's not you guys, then it's the fucking police department. It's one of you. But this woman right here, is a subject to a murder investigation of a Boston police officer. And you would think, because, you know, most times when people murder police officers, you know, they want to nail the murderer to a cross.
Clear is that we invited them to come.
That stuff would be there. Guess why? Because that is the most important evidence in this whole effing case. You got detectives losing jobs, all sorts of shit. I mean, I've never seen such BS in one trial, and they hire a mob freaking defense attorney just to rectify their shit. And all you do is whine, Brennan.
To the Canton Police Department, bring their expert, download anything that was on the DVR, which
I'm
nothing
good,
existed.
thank
And then
you.
we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously.
Oh, no, because when they went to go get it done after you said, oh, they don't need a court order, all they need to do is come by. Well, you came to the court and said they're going to need a court order. So they do need a court order, sir, because you guys play too many fucking games. You want to cry about ARCA because ARCA's going to nail your asses to the cross because you know that you got a flighty freaking whatever the freak is, accident reconstructionist. You got a stupid dude that says that he's a animal behavioralist, that whatever, he's made up his own degree. Then you got somebody that's coming in to talk that works on trauma victims with freaking cancer tumors in their brain, not somebody that's suffering a traumatic brain injury. There's a difference. And all these people are willing to lie for you. Plus the people that are lying about the freaking 2:27 a.m. Google search, dude. Like I said, you cannot use things as an offense and a defense. It don't work like that because it clashes. And you're going to be exposed. You guys should be ashamed of yourselves that you even went forward with this case. You have doctored videos. Disgusting. A police officer lost his job at how badly this damn case was ran.
Court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our
Okay, so I really don't want you talking to each other. I want you talking to me.
Oh my God, Bev. You want them to talk to each other any other freaking time? Now all of a sudden you don't want them to talk to each other? Get the F out of here. Because every other time is, why don't you guys, I think you guys can work on this. I think you guys can work on this. When he has stated he doesn't want to talk to anybody but Yannetti. You're full of lies, Bev. Like, stop. You can't ask them to do something and then don't want them to do it. Which one is it?
All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because
You asked the question to me. Answer it, Brennan. Okay, well, Brennan, hello, is not you, Your Honor. So, therefore, you are the gatekeeper. You need to answer it.
it contains files wholly unrelated to this case, and it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case, but they cannot have a photo image of the entire detective file of the Canton Police Department.
Why is it in the same fudging file as the other cases? It should be in its own file, sir. Own file. Now you want to say, oh, there's other cases on there. How many freaking crimes happen in your Sallyport, sir? How many crimes happen in your Sallyport? Does that make any sense to you? Then that means your police department is shit. And I'd root it from the toot it and get it the F out.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view.
Bev, Bev.
had asked defense
Hey,
counsel
Bev?
to propose
Hey,
something
Bev.
about.
Hey, Bev. You better write a freaking report, please. Or you better send an approval, because they're going to play games with this Sally Port. They've been playing games for 3 years. They ain't going to hand it over. You kidding? Oh, no, we got detective files in there. Who have you ever heard? What police department puts all their detective files in one file? No, they separate it out so that none of it gets confused with the other. Do you understand that, Bev? And I refuse to say Your Honor anymore, because you're. I can't believe we're going through this for another trial with you. You should have recused yourself when you had the chance, because this is a shit show.
About how Ms. Reed will get there. Have the two of you talked at all about how we're going to do it?
Right,
Two
Cole
sides
Pepsi.
We haven't talked about the logistics. I'm happy to do that. I don't think it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I
They
asked
all
you to
seem like they
figure out.
don't feel good. I
You say
feel
Ms.
bad
Reed
for
wants to
them.
go on
Like,
review,
they
she
seem
can go on review.
drained.
How do you propose that's done?
All of them.
The
All
citizens
of
are
them.
able
Like,
to prefer
none
to
of them have any
obviously jurors
spunk.
would be transported the exact
Like, none of them have any spunk. I noticed that yesterday during jury selection. They weren't their spunky, charismatic selves. Like, I think they came down with something. I feel bad for all of them. They need emergency something. They need pep in my step. Maybe go to an IV bar. Poor guys. I mean, they've been probably working on this case tirelessly. All of them. Even Karen. Because of the bullshit that they got to go through.
same way they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best
Like,
protocol.
this ain't the Jackson I know. He's more spunkier than that. Like, it just seems like they're all pretty drained. I mean, they went through 10 days of jury selection, and I seen, like, every day it was slowly dwindling down, like the energy, like the charisma. I think that's what the Commonwealth wants, is they want to run these guys ragged. I mean, damn, they've had 3 years no sleep, basically.
I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the
Okay,
jurors.
you know what? 9 times out of 10. Hold on.
Observe.
That's another thing I want to talk about. Okay, when they go for a jury view, usually the defendant gets to go in the same vehicle with their attorneys, and they're not allowed to talk to the jury, and the jury's not allowed to talk to them. What, you guys so afraid that Karen's going to talk to somebody? I don't think she would put up her damn bail that quickly to talk to somebody like that. But
Same
the
circumstance
Commonwealth
that we
would.
observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle, because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and the
fine.
rest will be on the bus.
That's fine.
I do need you to talk.
Well, the Commonwealth doesn't need to be alone with them. Hello, ma'am. The Commonwealth needs to be in a separate vehicle too. I don't trust them. Look at what they've done.
To figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference
great.
was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was
No,
my
you
concern at
didn't
time,
want
but
the
that's at
vehicle
request.
there.
I'll
No.
agree with it.
Don't try
The
to
date of the
back
view?
out now. You wanted it in 2 fucking separate places, sir. The defense is the one that wanted it at the crime scene. I just love how you like, you act like you wanted it one way and not the other. You're so dumb. Like, Hello? Like, how are they supposed to come to a conclusion if the vehicle ain't there? It's a small damn roadway, a small damn freaking yard. I think it should be there because it's a kind of a big car. To see if can I imagine this car going 22 miles an hour backwards and not end up in the middle of the yard or in the house for that matter? And only I see a little bit of tire tracks or a little swirl because that's what the stupid people said. Give me a break.
I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anymore?
Right, like Karen's not dumb. And she wouldn't put up her damn freedom. And Karen went up there. She ain't fucking around. And poor Yanetti's like, I need to do my damn thing so I can go. He's like, poor dude is just sick. He has to go. I know that they just don't feel good. It shows like their energy's way off. So whatever they have, I hope they hurry up and get rid of that shit so they can have a great day on Tuesday, you know? They're all so run down. It's sad. It's just sad to watch. Absolutely sad. Do 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 do. Yeah, I think Nettie goes. He leaves after this. Okay, why am I waiting this long?
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
Why do you
The agreement is there's
you ask them to get together. See, Bev, you want to be included. You always want to be included, you know. Don't talk to him, talk to me. But then you tell them talk to each other. I think you guys can work this out together. But you always want to be included.
going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay. All right, thank you.
Your Honor.
Cold Pepsi,
Okay.
great minds, you know.
So, Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
And this,
I do. I received it last night. I haven't read it, but I
Let 'em
discussed
out.
it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
we want Lieutenant Wing out.
Your Honor, the defense proposes Mr. Wing as a dog bite expert.
And he
I
is.
think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think.
Brennan, have you looked at his videos? His videos are great. His videos are great. And I think you don't want him to come in with his arms, the prosthetic arms, where it actually shows dog bites. And guess what? They match up to John O'Keefe's arm. You don't want that, do you? You don't want that, do you? Huh? You're afraid of him just like you're afraid of Arca.
I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume.
What? He has been a dog bite expert for over 20 years. He's been a dog trainer for over 20 years. He teaches the bite and hold technique, the ones that go owie, owie when a prisoner runs away and shit. Yeah. He's the trainer for those dogs. Okay. Maybe he'll send one to bite your ass. How about that? Because you got a stick in there. It might want to play fetch. And pull that bitch out. You are afraid. See, you're afraid of all their experts. See, and they're not afraid of any of yours. They just, your experts aren't experts. And that's their problem. They wouldn't care if your experts were experts. You got Dr. Crosby that says he's an animal behavioralist. Since when do they have degrees for that? Or what is it? Animal science degree in animal behavior? There is no such thing, sir. And you want him to look at John O'Keefe's arms and say, oh, well, look, Chloe didn't make those arms. I guess you guys found Chloe out of thin air and stuff, but she was never available for the defense in the first trial, but you miraculously found her. He's not saying a specific dog is going to a specific wound. He is just saying those are classic bite marks.
May. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified.
And Dr. Crosby is not a medical expert. Now, is he? You want him to freaking say that some stupid whatever, they took a mold of Chloe's mouth and the teeth don't match, but it doesn't do an over whatever. Anyways, she granted that expert. You're such a crybaby, whine baby bitch.
Individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that.
Let's see. I can't remember his YouTube name. It's American Dog Training. I think it's American Dog Training. That's Lieutenant Wing's YouTube channel. He has over 2 million subscribers. He has been a dog bite freaking trainer, a dog trainer, a police dog trainer for 20 years. He also talks about police dogs that didn't make being a police dog, Chloe for that matter. Also civilian dogs, he's trained civilian dogs. He knows about dog training, but behavior, like a dog behavioralist, a dog behavioralist. Okay, I know that they do have some people that do that, but it's not a specialty. It's not an expertise. All they do is they do certain things to the dog. It's like a dog aggression training, or not training, but to find out if the dog's aggressive, right? And what the dog is aggressive about. They do that in the kill shelters and stuff like that. But as far as being an expert in that, I've never heard of it. I've never heard of a dog bite or an animal behavioralist expert, which is weird. But Dr. Russell, she with dog bites for a long time because she's been an ER doctor, medical doctor. You got somebody that's coming in to say the ground was hard. The ground was frozen when the ground wasn't fucking frozen. Then you got some neurologist. When you have a neuroscientist that came in and testified about John's brain injuries when the first trial, where, she said like some boxers can get that kind of head injuries, but nobody, cross-examined her on it. And they're not typical car being struck with a car type deal, because cars hit lower to the ground than up. But hey, but no, some of these experts aren't experts on the Commonwealth, but whatever. And the ARCA experts, they are the feds go to. They are some other group, but they got some high up there. I mean, they don't just do car accident reconstruction. They do a lot of things reconstruction. So they are nationally accredited. And he's afraid of it. He's afraid of all their experts because he knows his experts are trash. I mean, you got people coming in saying that Google, that's not what, no, that wasn't Googled at 2:27 a.m.
That Mr. Wing has ever testified in court before. And so to expedite the matter.
Because they probably haven't had a case involving dog bites, dummy. Or they don't even know who he is. Who cares? Your expert says he's testified 1 million times. But no one can find where. Where? Dummy.
Look or seek a Lanigan hearing. I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
They handed you over all his stuff, sir. Let's go, let's see. Yeah.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right. Okay. That has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition.
He's got arms that show it.
Methodology, unlike that of Dr. Crosby, is stated in his report. And in addition, he cites 2 specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And
Let's go.
we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby.
Let's go.
And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that
She's going to deny your motion because she denies every last one of your motions. Every last one of them. Every last one of them. She has maybe let one or two in, but she's denied. And if she's letting Ark in, she's definitely ain't letting him in.
have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear next.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because.
Just go ahead. Just move on.
Yeah. So my request would be that a determination on
court TV,
whether or not there's a voir dire of Lieutenant Wing, abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby.
I don't like how you try to rush them through it, but he can spew all this BS and all his flunders on the defense, and you do nothing, Bev. They ask you time and time again. What's good for the goose is good for the gander. And you refuse to. You refuse to hold him accountable.
Tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert.
Absolutely.
I'm not going to reconsider.
That is absolutely crazy that you're just going to say he's an expert.
Consider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected, I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold.
Sir, they're not. You guys jump the gun and think, oh, well, they have a big dog. It might have been her. But they're just saying might. They didn't say automatically. And you look at your consciousness of guilt. Hurry. Let's find somebody. Let's hurry up and do the DNA swabs. Even though we didn't swab the arm itself, let's hurry up and, hurry up and do DNA on that.
Of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds
who's to say it was her teeth
were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal.
They also said about claws, sir. You're just focusing on the mouth. They're also saying claw marks, sir. What do you got to say about that?
Not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcode it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. Right. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
Just
motion.
for the court, the Commonwealth will provide a copy to defense. That's
Okay. Thank you. Can I have the defense what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
May I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
Well, we could have somebody playing clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case to bring him back regularly as a police officer.
Well, they had a police officer reading it. Nobody's a witness to them other than Karen and John. John is no longer here, sadly. And Karen ain't gonna get up there and do that shit. But you guys insist that it's so damning to the case. Those text messages are normal boyfriend-girlfriend arguments. There's nothing, she's not saying, I want to unalive you. She's not saying that, dude. But you guys insist that that's what those say.
I think creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Barino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back.
I wonder if he's going to
doesn't
say
matter how many
kill
times
me
he comes
on the
back, he's paid by the
staff.
state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be. And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood it to be to take out all infliction, and completely that.
Right.
Well, you didn't have an
I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly
I get what he's saying.
Objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you.
Yeah, you say
All right.
that.
Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5? Yes. With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable.
God,
It's
shut
irrelevant.
up.
It doesn't show any bias on behalf of the witness. If they had any reluctance or concerns about testifying, I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific
Shut
requests,
up,
which
Brennan. No,
extend
you
beyond Rule
haven't.
14, I am more than happy to give them.
You've
But I
been
think 3 and
lying.
4 are personal, irrelevant, and have nothing to do with bias or
Where's the
credibility.
Sallyport video then, Brennan, if you've been so forthcoming? Where's the Sallyport video?
Okay. Thank you. All right. The ARCA witnesses. Motions
go.
regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is,
Brennan, you're asking them to turn over stuff that they didn't have. They just got clearance to talk to the ARCA witnesses, to engage with them. But they haven't been able to engage with them this whole time until March 26th. That is just like 2 weeks, 3 weeks maybe. So they handed all over your expert stuff and said, if you need to do more testing, do more testing. If not, boom, we're done.
we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025,
you've been wanting to exclude
docket
them from
642.
the get-go. I don't know what it is about them or their accreditation or whatever, or where they came from that you're afraid of. But you're afraid of them for some reason. Or you want, that's right. You want to tie Karen's hands behind her back and let her not have a defense, right?
Two, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. And that is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items,
because it hasn't
I expect
been,
would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my 3 requests.
Only 3? Okay, let's go, Jackson.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, the reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional
Brennan
analysis or testing done, that will be turned over
court, and that gave her grave concerns
with
about
regard to docket number 642. We did, Your Honor. I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points they were?
I knew the
Because this is on what
if
you
I,
filed.
got
So,
involved in these.
This is not unusual. A party says
It's none of my
we asked for all
business.
13,
But if
another
they
party
go
says
back
we gave
to
them to you, and then
their
the party says, I don't have them. Can we narrow this? Is there
their
anything
voir dire from
specifically that
last
Mr. Jackson should address?
With
Yes. Their response is that it's not in their custody.
they go back to their voir dire from last year with Dr. Russell, then the 2 ARCA guys. If they went back to that, and when he stated that, there was more information than was given, was blah blah blah, that they were having secret conversations without the Commonwealth knowing, and it gave the judge grave concerns. I don't know why the hell they didn't go back to the voir dire, the very first voir dire, because Jackson states in there, and I know it's somewhere, because I was going to go over that voir dire before the trial started. It's like day 24 or something. But if they actually watch that, Jackson says that email word for freaking word. They didn't hide shit from the Commonwealth. They didn't hide shit from the damn judge. And he made it seem like they were.
Control.
So for which ones? Which of your numbers?
Number 1, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried
this
to
is
prevent.
why I hate
Okay.
you.
So address number
Because
one,
you
Mr.
just
Jackson.
do
Number one
all
issue
this
that Mr.
lies
Brennan
and
has
bullshit.
anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So
That's what
address
we did
number
not.
one, please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rensler.
Yes.
That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests.
Hey,
I'm happy to do that.
Kevin.
If the court's satisfied with
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness
They
did regarding
specifically said
testing,
what they did.
preparation, things
One
that are
guilty
normal
Kevin.
cross-examination. Is that clarified any better?
One did the causation
They
of
said
the
we.
injuries.
They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rensler talked about what he did, which was more on the biological side.
There's a difference
Right.
between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their
They sure did.
specific capacity was and their expertise. We had not received
Together,
any additional
they're a
report
whole.
to that effect.
That's why they
Everything
say
that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they
Yeah,
cannot
none of
provide
it's
because of the federal
little,
investigation?
Bush.
Not to my knowledge. I don't know.
No.
I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult counsel just for a moment?
Sure.
Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government.
And that's what Brennan
So can
wants.
they testify as to what they did?
Yes, that is on. That's
Can
on
they
the table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see counsel attack?
Oh my God, why does this have to be a fucking sidebar, lady? You let him spew all this bullshit, and here he's gonna come out and say, "Ring, ring, 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 ring." God, I don't want to look forward to him during this next trial. And Nettie's leaving. You don't feel good. There he goes.
All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report. And that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were
All right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA
Like, what are you
does
getting?
not list
Like,
were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did
that's
you
what we
do?
provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about
Oh
since the
my
beginning of this
God.
case. And I've made
Stop
every
with the
effort
dramatics.
to alert the court that I had a concern. In fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never.
Bullshit.
But it was to preclude the defense from trying this case by
In
ambush.
every motion, you
And it was
said
my primary
exclude them,
concern, and that is why-
exclude them, exclude them, exclude them. In every motion, dude. So tell me again that you weren't trying to get them not to testify. You talk out both sides of your neck. One sentence you're saying, "Oh, I'm not trying to exclude them," but at the same time you're like, "Exclude them."
I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the
Well,
basis of
that's you.
opinion, but regarding communications between the defense.
Well, hey, they don't have full disclosure of the Sallyport video, sir. How about that? What's good for the goose is good for the gander.
In ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled.
You have everything.
The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tool request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionists they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch a CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and.
Okay, your experts. That's the only reason why they'd have new opinions is because of your experts, dummy.
Conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to the discovery deadline. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort.
Other than your $250,000 that you get paid, I guess. Sir, you don't have an investment in this, where Karen does. Karen has a personal investment in this. You guys have nickel and dimed her, making her come up with these experts because you got these loser ass experts that are going to try to say this way, and they have a right to defend against your experts, sir.
Decided to make and wait until March or February 7th, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to
do. Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a two request. We asked for a 2-week permission, or ask permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them and we intend to use them to, at the very least, to address.
But they're saying basically like you should have spent $250,000 on experts, even though she's got limited means and been nickeled and dimed this whole way through, that you're supposed to pay. And because the federal government said we in good faith can't see this case going forward, yet they still brought charges on her. So they said, yeah, you can use our experts. Either side could use our experts. It wasn't one way or another. The defense seen their way. I want to hire them. They've already done the work. They've already been paid for. All I have to do is pay them for their time. I mean, hello, they ain't dragging their feet. Yes, they could have hired their own experts, but they don't have the money. She's already $5 million in debt.
Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dried. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Kearney from to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any
Maybe we're
statements
gonna
that are
go ahead
relevant,
and work
we think
with
the defense
that.
is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are
But it
limited to
has to
certain
do with
conduct,
this case.
but don't include other types of conduct.
It
which would be
has to
rebutted.
do with this
Third party's
case.
opinions are not admissible to impeach a witness.
They all have to
The
do with
defense
this
vehemently
case.
disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that.
Oh my God.
Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate
Doesn't want
officers
it
in this
out-
case.
You
out
know what? I
loud.
do need that in writing.
She doesn't want it out loud.
I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see
Okay.
whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Jim, I need that. She needs that, Jim.
I would say that's only the audio, there's the visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay,
That's the audio, but there will be the visual with it that was aired.
okay. I was able to see the video.
Super.
Okay. All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay, all right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay, so Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is
What
strong
does that have to do with
likelihood that
third
we would
party culprit?
call Mr. Kearney.
What does that have to do with third party culprit? He's just a reporter. He reports on things that he feels is a little bit shisty.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
But can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness
Okay.
intimidation.
So just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
Got a minute.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
Can you work through lunch for a little bit? Yeah, let's get this show on the road. Action.
You are unmuted.
Lights, camera, action.
Court is back in session. You may be seated.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
So you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
The SC just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to assert his Fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
He's part of the Illuminati. He was sitting there through on the Illuminati sign. Well, that was an eventful motions hearing. Karen Read will be
Tori,
going
Jim.
to trial on next Tuesday. Next Tuesday opening
All right,
statement.
so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may,
Who's
just for the
gonna list
record,
them all, Your
maintain
Honor?
the same objection I had at the last trial. Don't need to make any
Oh,
further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy. And
it is something that we've done.
right, understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, for the court, please.
See you Tuesday. She goes back to trial. Yeah, wow. Anyways, so that was fun. Thanks everybody that came by and hit the like, shared the live, commented, subbed if they haven't, because I'm on the road to 1K and it's a slow freaking process. Nobody likes me. Just kidding. But anyways, I appreciate those that come in and support me. You mean the world to me. And also let the ones you love and care about know that you love and care about them, because tomorrow is never promised. And check your surroundings, because you never know. This could be you on the other side. Have a good day. Okay, everybody, stay blessed. Bye.
Put your eyes on me, like the spotlight. Recognize me, showing love, and got my grind right. Ain't never since day one, the love been on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be. Definition of business, definition of friendship, definition of rider, definition relentless. She's a strong woman, she's a sweet lady, she's a great mother, the pain get aching. Yeah. I made that girl on YouTube. She never dims my light or put me in her dark mood. And I thank you. You appreciate. You're my favorite girl on YouTube, and I can't fake it. Still got faith in me. Make me feel like big. DJ Khaled voice. Pretty idea. Still got faith in me. Make me feel like big. DJ Khaled voice. Pretty idea. Yeah. Made a little shout on this show called BGP, you know what I'm talking about? Shit. We been cool ever since, my nigga, you know what I'm talking about? Put your eyes on me, like the spotlight. Recognize me showing love, then got my grind right. Ain't never since day one the love been on side. And since you got my back, I got your back for life. Yeah, pretty eyes see. Know just what it is, I got it on me. Hey, you gon' be down, you like my homie. Just know I got you, dog, just what it gon' be.